Hi, I'm Michael Coates, founder and president of Medical Lien Recovery. Today we're going to be covering a presentation on the ethics of personal injury. First, a little bit about Medical Lien Recovery and the company that I founded. MLR has represented hundreds of medical providers in thousands of matters throughout California, maximizing personal injury lien bill payments when patient attorneys seek to slash your bill, take your med pay, won't communicate, or won't budge. We were the first company doing this. It's starting in 2012, and to this day, we are, to our knowledge, the only company that focuses solely in this area. Now, as you listen to this presentation, I want you to realize you're going to be overwhelmed by the volume of information and some of the complexity and nuances involved. Don't feel like you have to learn it all right here. Some of this whole presentation was really done for a 2-hour continuing education presentation, and we've got this down to an hour here. So some of these topics I'm going to run through very quickly, glance over a few, but realize you have these slides to refer to later. Plus, Medical Lien Recovery does have the mlrportal.com, where there's a free course to learn some of this in more detail, and the expanded portal covers everything in incredible depth, including forms and tools that staff can use to respond back to attorneys. So getting on to the presentation itself, let's talk about the players involved in personal injury, their priorities and their motivations. Everybody revolves around one person, and that's the star player, just like in sports, and here it's the patient. So everyone's focus revolves around the patient. The attorney for the patient here is very similar to an agent in sports. When that star player gets that huge contract, that $30 million a year contract, that attorney is, or that agent, I should say, is getting 15%. They're the financial coach. Their focus is the financial welfare of the star. Then there's the medical provider, you. You're like the trainer, the health coach. Your job is to keep the player on the field. Now, someone's got to pay for all of this. And in personal injury, that is the insurer, who's represented generally by the adjuster. In sports, that would be like the owner of the team, and they're really the bank that funds this all. In fact, they're also kind of the big bad wolf in PI, because of the games and things insurers do is what trickles down to the attorneys, that trickles down to you, and trickles down to the patients. And the problems we're going to talk about. Now, what happens when there is an issue and a problem? Well, in sports, you have a referee or an umpire that gets involved. When it involves this area, you've got the court or a judge. They're going to make decisions, call fouls, and determine who's right and who's wrong. What happens when things are really egregious? Some really bad things where, to be honest, there have been either laws broken or ethical rules violated. In sports, it's the league head office. They can terminate, suspend a player. Here, it is the state bar for the attorney, and it's the medical board for the medical providers involved. One thing I really like to emphasize is that a little due diligence goes a long way. This is analogous to game preparation as you're preparing as a sports team, because the game might not be for days or weeks when you're playing, but there's a lot of homework that goes in so that when you do get on the field, you execute things as flawlessly as you can for a great outcome. This is no different in personal injury. First area I want to talk about is liability insurance policies. Something like we talked about the insurer that is funding this all, well, that arises because of the insurance policy. Let's use, for example here, we'll mostly be talking about motor vehicle accidents, although personal injury can involve slip and falls and other areas. But here, the first policy that is generally involved is the other driver, the one that hit your patient or caused the problem. That third-party policy is going to have certain amounts, and knowing those limits, or whether it even exists, is going to help to determine how you might approach at least the payment of treatment. So for third-party policies, you know that there is a $15,000 minimum for an individual and $30,000 for multiple people. So that's kind of one pot, and hopefully it might even be higher. The second insurance policy you want to always be aware of is the patient's own policy. Why is that important? We're going to talk about it more in depth later, but there's two areas of primary import on the patient's policy, and that's going to be med pay and underinsured motorist coverage, which, like I said, we'll cover a little more later. The next item is property damage. Like anything else, the more severe the property damage and the injuries involved, then the bigger the severity, well, the higher the potential recovery in the patient's case to support higher medical bills. Photos are the best thing in the world. If you are able to see photos of the car damages of your patient and the other driver, you're going to get a good indication whether an adjuster or someone looking at it might be trying to fight harder because of the severity of the accident. Because some of that depends upon the type of how expensive the car is. You know, a high-end Mercedes having a scratch on the bumper could still be a $3,000 charge, but that scratch on the bumper of an older car, may only be a few hundred. So don't go by just property damage estimates. Photos will really tell the story. Next is medically necessary. All you can do, should do, or will do is what's medically necessary. And that is both as to the treatment you provide and the scope of that treatment. Part of what you're gathering here in that due diligence is you're part of a health team for that patient. Now, if you're the chiropractor, you're generally going to be the head health coach most of the time because you're the first non-emergency treater that patient's going to see. So you're the one that really has the primary control of the referrals going out that we'll be talking about later to specialists for either an MRI, pain management consult, whatever might be needed by the patient. But assembling that health team, knowing who are good treaters, good providers, and also take on lien is going to really help to set the stage for a smoother process in personal injury. Next are solid processes and paperwork. When you build a house and you have a strong foundation, whatever you erect on top is going to hold, even in a good earthquake. But if you're building that house on sand, that house is going to tumble over, slant, and it's not going to stand. Well, in business, the foundation for almost any business starts with contracts and is with keeping good records and then also having a plan for your business. Well, the same in personal injury. Here, the primary contract involved is the medical lien agreement. We're going to talk about that in more detail, but that's the key document. The log that's referenced there is a communications log, so you're tracking the communications with the attorney because you're going to be following this case for a long time, often until it does get resolved, and then having a plan for the patient, getting them back to health, and also what you're going to be doing in follow-up until you are finally paid. One of the biggest areas we find where there are issues is in the area of expectations. Unfortunately, many patients don't have the realistic ones. We'll get into that under an area we talk about for patients. But the main thing here is the patient owes the bill regardless of the outcome of the case. We're going to talk about that a lot. It's one of the reasons why the patient is the star player. So there's nothing wrong with considering lien reductions and how you approach PI. Just realize it is, and as you should be telling your patients, on a case-by-case basis, and realizing there's self-interest from the patient and the attorney involved in all sectors. Another area is litigation economics. A really important part to understand because there is a huge difference for attorneys between settlement and trial. When you try a case, especially if there's a liability dispute, it's an incredibly expensive process. You might have accident reconstructionists. The other side has expert doctors to counter the doctors on behalf of the patient. And when you're doing depositions of experts at maybe $400, $600 an hour, that all adds up. And a lot of depositions, probably $1,000 to $1,500 per deposition. Again, it's all adding up. So what that means is, unless there's probably about over $100,000 is what's preferred by a lot of attorneys to take a case to trial, I expect if you don't have at least probably $30,000 in medical specials, it's really hard to take that case and make it justifiable for the attorney at trial. So what happens? Most attorneys then settle. They try to get the insurance company and the adjuster as far as they can, and then a decision has to be made. Is it going to be tried? Is it going to be settled? If it's going to be tried, the law firm or attorney involved might handle it themselves, or they might bring in another law firm that has more resources to take it to trial, better suited, or more trial experts. And we'll get into that a little bit more later on. The first decisional point that you're going to have with patients in this area is that very first visit. You've got to decide how is your business, which is a for-profit business, going to be paid. That can be by cash, by insurance, on a lien. If you're a surgical provider, then you've got financing that might be involved, and then you can have modified arrangements. So you've got to decide what you're going to do with that particular patient. Again, if it's real small property damage, but that patient really is hurt, you might decide to do some modified arrangement. Maybe part of it's going to be on lien, but at some point you're going to shift to something else. You've got to decide what's best for you and the patient and come to an agreement on that. One of the larger issues, certainly in the state of California, is the area of MedPay. MedPay is restricted to medical expense reimbursement. Throughout the country, there are some where it's optional. Only 2 states require it. Some there is regular MedPay, which is just paid out. There is no right of reimbursement. Most of it today is reimbursable, meaning at the end of the patient's case, if they paid out monies for MedPay, they have an opportunity to get some of it back. We'll talk about that in more depth. Your state may also have, instead of MedPay or in addition to MedPay, PIP insurance. PIP is in about 15 states, 12 no fault, 3 tort. Now that covers more than just medical expenses. And that can cover lost income or even child care. So it's more expansive. Realize if you have that in your state, you want to always go after that. Really important to identify it and then go after it, because as opposed to waiting years to be paid, these are all set up to pay medical providers fast, to encourage medical providers to treat patients that have been hurt. That's why the patient pays for that on their policy. A real issue that is not addressed, I think, enough in this area by providers or even insurance companies, and even by the knowledge of providers themselves, is the profit margin difference among providers. The difference between a profit margin of say, a chiropractor, an acupuncturist, or a physical therapist compared to, say, an MRI company is night and day. You might have a $2,000 MRI bill that the MRI company may very well be quite satisfied to get $400 or $500 for, because it's a high volume business. That $2,000 is charged on a single visit on one day. Now you take the chiropractor, the acupuncturist, the physical therapist, or as we call CAP providers. Those are high patient visit volume providers, lower profit margin, with a lot of staff overhead. So that $2,000 treatment by an MRI on a single visit probably is covering maybe 15 visits or more with your office, if you're one of those CAP providers. So when they get their bill slashed, it's not the same as when you do. This ties into what's reasonable fees. Reasonable fees, some might say, is with the viewpoint of the beholder. Certainly, I can't remember an insurance adjuster that has ever found any medical bill to be reasonable. It's part of the games they play, so they're all improper. In fact, Colossus, a software that most of the insurers use, is really designed not to be an expert in trial. It is designed specifically to provide some bogus third-party support for paying lower on your bill. And there's lots of games on the insurer side utilizing Colossus that is improperly reducing your bill for purposes of the lawsuit. Remember, Colossus and the viewpoint of the insurance company is not the standard that is applied to your bill. That is merely the standard in the patient's lawsuit, but it's not when it comes to pay your bill between you and the patient. This ties into that next item, the difference between attorneys and medical providers. Attorneys are paid on contingency fee. That means, like you see on the late night television programs and you see an advertisement, they say, if we don't win, you pay nothing. Well, that's exactly what contingency is. They win, they get a lot. They lose, they get nothing. Why a lot of law firms take an incredible number and volume of patient matters, the small ones, because some of those small ones turn into the big ones. And when they hit on the big one, that can be hundreds of thousands of dollars, if not millions, to the law firm, paying for all the little cases that come around. Now let's shift over to you, the medical provider. The problem with you is you're not on contingency. You are more akin to a creditor-debtor based upon that lien agreement contract. You can only get what your bill is. Maybe interest on it, of course, and consequential damages, but nothing like some huge bonus. That's what you're limited to, regardless of the case. So if the attorney drops the patient, you've got to go after the patient or you have nothing. And that next case doesn't make up for it, because once you lose, you've lost that money and cannot get recovered because you get no bonuses. So realize the difference. You are not paid the same, and you need to realize when someone's talking about you just like the attorney, you're not. The key document, as we referenced, is the lien, because you're paid based upon that contract, and the contract controls, not the custom and practice which a lot of attorneys try to tell you. It is the lien agreement. The most important person signing that lien agreement, believe it or not, it's not the patient. It's the attorney. Because by the attorney signing it in California, especially, that makes the attorney have fiduciary duties, the highest duty of care imposed by law, not just on their own client, but also on the medical provider monies that they receive. Let me give you a great example to show that. Let's say that the patient didn't sign the lien in California, and the patient at the end of a case said, hey, to his attorney, send me the doctor's money and I'll pay the doctor, wink, wink. Meaning he has no intent of paying the doctor. Well, the attorney probably has no choice because of the fiduciary duty but to send the patient the money. However, if the attorney did sign the lien, no matter what the patient says, the attorney cannot send your money to the patient unless you've agreed to do that. And when they do that, that creates big problems on the part of the attorney. They did something wrong. This also gets into why which attorney matters, and they do. There's no better company, or I should say industry out there in terms of data and algorithms than in the insurance company. Just look at when we go to apply for health insurance. Based upon our height, our weight, our age, it's going to change on how much we pay, how much they'll extend. Well, those same insurance companies got really wise long ago, and I used to be an insurance defense attorney. They were able to monitor and keep track of how all the attorneys did, from how long it took them to file a case, to whether they did file, to whether they took it to trial, to whether they actually went to a jury verdict, and then the success they had. And all those things gives them a lot of information to know which attorneys to press harder, which attorneys they've got to watch out for. So which attorney matters? That's for the lawsuit itself. Then it comes which attorney matters when you're going to get paid on your lien. Generally, that's going to be because where the attorney geographically is going to make a big difference. If you're a Southern California LA attorney and you've got Northern California providers, then you're going to find that those LA attorneys are going to generally not protect the Northern California providers. And I get that every day, and lots of cases with MLR representing Northern California providers for that very reason. So you've got the difference of geography. You've got the difference of the data that the insurance company takes. And of course, some attorneys are just great at trial. Some are great at pre-litigation. Most are not great at both. Some are. And you may not know who those are. If you keep track of the results by the attorneys in all your matters, we actually have a form that's for an attorney audit on an Excel spreadsheet that you can keep track of the results from all your matters. You're going to know how well you really are doing with that law firm. Now, just like the attorney matters, so does the patient. If you're taking this on a lien, that means you're waiting to be paid. And there's always the chance that that attorney is going to drop the patient. So if that patient has a good job, owns a house, all those things mean your risk is a lot less. If it is someone who's been unemployed for whatever other reasons, you are going to maybe have a potential problem of being paid. If it's a minor and a young minor, you might have to wait until they turn after 18 before it even gets resolved. Generally, that won't occur if it's a family that got hurt, but if it's just a minor, that happens often. So realize, if you do it on lien, it may be a long time till you get paid. In the end, from all this game prep, I want you to realize you don't know what you don't know. So you want to try to find things out, and hopefully from this presentation, you're going to know a lot more than you did before, and then there's still going to be things that you don't know what you don't know. Let's shift into the game fouls. We're going to go to the different segments of the insurer, the patient, the attorney, and the provider on the things that they specifically do wrong. Again, as I mentioned earlier, I'm probably going to run more briefly over some of these because of the time limit that we have. But the first is on the insurer. They delay, deny, devalue, and or defend. As what you see on the bottom, I like to analogize it to the Survivor game show. It's outwit, outplay, outlast. Why is it that insurers really delay things? Well, for very good reason. It's why when you see all these tragedies occurring throughout the country, think of the fires in California, the hurricanes in Florida, the floods in Texas, the tornadoes that are rushing through the Midwest. Billions and billions of dollars that are paid out by the insurance companies. Why aren't they going out of business? In fact, why are their profits going up? The reason is how they make money. All those premiums that all of us or other people pay to them gets invested. They pay out on all these lawsuits the profits from the investment. Well, the longer your investment is working for you, making you more money, the more money you're making. So the more they can delay paying things out, the more money they make and how much they keep in their pocket. And like any good business person, which you should be, it doesn't matter how much you get, it matters how much you keep in your pocket at the end of the day. Insurance companies are really good about that. And you deal with the fact of robotic adjusters. They do the same thing every time. It's not easy for a lot of these attorneys dealing with these adjusters. Some of them, while are experienced, some of them are not. Some of them just don't care and are just going to follow whatever is the rule book that they have. Then you have where they're going to, the insurance company's going to just blame game, the blame game. Now, some of the blame may be completely legitimate, but many times some aspects of it are not. So whether it's liability, damages, the patient credibility, or your bill and your treatment, those get asserted to put things as a reason to why they should pay nothing or pay less. When they do decide to go forward, oftentimes it becomes more of a scorched earth, time and money. They're going to hire a defense law firm, a defense attorney, that they've got to pay by the hour. And since I was at one of those firms before, or actually have a few of them, you will know that they churn a lot of hours. And so a lot of money is going to come out. It's one of the reasons why more aggressive law firms on the plaintiff side often get higher settlements by filing complaints earlier, because that insurance adjuster's got about 60 days, given an extension to answer, to hire that defense counsel. And they know once they hire them, they're going to pay out more money. So doesn't it make sense? You'll offer a little bit more money to try to get rid of that case now before you spend a lot more. And this gets back to the analytics. They know on the patient attorneys a lot of the tendencies, and that's going to also guide how they act. Another game foul. You may have an assignment of benefits signed by the patient that says on their MedPay, for example, it's to be sent directly to the provider. Or at the conclusion of the lawsuit, pay the provider directly. But a lot of the insurers don't. What they do is send that money right to the patient's attorney. Now, why do they do that? Remember back to one of our initial slides. The patient is the star player. The insurance company is not worried about you, the provider. They're worried about, especially, their insured, if it's MedPay, because that patient could say 2 words to them that gets them shivering. Bad faith. Bad faith opens up all kinds of bad potential doors and damages on insurance companies. So they don't like that. So they feel, hey, we are safer if we send that money to the patient's attorney and let the patient's attorney send it out and deal with it. Now, the problem by them sending it, it creates other problems we're going to get into on the fouls by the attorney. So let's shift now over to the next person in the chain, and that's the patient. They are not without fouls either. One of the largest ones simply comes from what we talked about earlier and touched upon, which is believing that a personal injury case is a financial windfall. What that leads to is when you don't have objective signs like a disc bulge, broken bones, surgery, the problem is you don't know whether they're being honest with you. How bad really is the severity of the injury? Now, you've got to go by what your patient is telling you. All I'm saying is that in the lawsuit, there's going to be a bigger debate about that. You may have, though, that issue come as you continue treatment and a patient continues to prolong treatment, not getting helped enough like your usual patient, or something's occurring which indicates to you, hey, something's going wrong. Something is off here. If you have red flags go off, you should be exploring that to see if it is game fouls by your patient, and do you have and identify if you've got a problem earlier. That could be the absentee patient. Believe it or not, some won't show for a visit. They'll call you up and say, hey, my attorney said I really need to be there, so can you please sign me in so I don't harm my lawsuit? This has happened more than a few times. And there's even been instances where the attorney has called the provider and asked that to happen. That's fraud. Don't let it happen. In fact, there are still companies, or should say criminals out there, that set up accidents. They're fake accidents, fake injuries, and they are simply trying to bilk money out of the insurance company. You've got to watch out for those. That could be a red flag for that. Then there's the uncooperative patient. If they're not following your rules for treatment, probably they're not following what their own attorney is asking them to do. You're going to have a problem there. Or what about the patient that abandons their own case? Stop pursuing. Drop their attorney. Drop the lawsuit. Leave town. Or they're hiding things, that they switched attorneys. They don't tell you. They moved again out of state. One of the areas that's really not their fault, but I still put it under game fouls, is they're uninformed. Because they're not asking their own attorney questions and following up. Their attorney is doing things wrong, but they don't know about it because they're not being told what's being done, or including even their own case progress, or they're misinformed. Remember, we talked about those advertisements and TV commercials where the attorneys say, if we don't win, you pay nothing. Well, believe it or not, some of those law firms actually tell their own clients, well, you not only don't owe our bill, you don't own the provider's bill. Now, that's going to be rare, but you'd be surprised at how often when an attorney drops a patient and the provider now is going to go after to get paid by the patient directly, and the attorney finds out about it, they get really upset. You're chasing the patient. They shouldn't be, but that's giving you a highlight of the last item, which is the greed factor. Self-interest is going to win over relationships. Generally, whether your relationship with that attorney, or even more so with that patient, when there's a pot of money sitting there, oftentimes the pot of money is going to win over you. Now let's shift on the area we're going to spend more time about. And that's the fouls by the attorney. Some of these are actually violations of ethical rules and even law. Some of them are more just fouls, I call, because they're just bad practices or things you've got to be at least careful of. One is the hands-off attorney in pre-lit, where especially those high volume, the law firms you see advertising a lot on TV, a lot of the cases are ran not by the attorney, but they're run by the underlings, law clerks, not even attorneys. When it gets to liens, it's lien specialists that really have no real credentials most of the time. So you got to be careful with who's handling what with a law firm. Then there's those that are really passive with the insurers. It doesn't mean that it's wrong if an attorney takes time to resolve a case. There's a 2-year statute of limitations. The problem is if a law firm is always waiting to the end of 2 years, that's going to be a really high red flag for you, because they're usually probably putting that case off to the side, and then you're just going to be waiting a long time to always be paid. Those that are more aggressive, they get that first really lowball offer from the insurance company, they file. They start the clock running. They get those fees up faster, and they usually will resolve it faster, maybe within a few months of the end of treatment, or within 6 months or at least a year. So aggressiveness can matter. Then, like anything else, experience. There are those who are really experienced that know, even though you may have a $15,000 limit on the insurance policy, know how to open up that policy to where the insurer may have to pay more money if their attorney or their adjuster doesn't do things right. So experience can really matter in this area. You'll also find attorneys that they aren't focusing just on PI. You should always research that attorney. Go to whatever state bar you're in. They will generally have an online listing. You put in the attorney's name. It will bring up whether their current status, if they have been suspended, terminated, have they got prior complaints on them. You want to know that, because that's going to tell you not only about how experienced they are, because you'll see the year they often got their license, but you'll see if there were other complaints. In California, you can even pull up PDFs of actual decisions that will show what they did if they had actions taken by the state bar on them, and some of them will even note they were about not paying medical liens. So you can ask some of that by public information. Then you get the law firms that are the pure turn and burns. They are taking that incredible number of lawsuits in. They cherry pick the good ones that they'll spend the real time on. Otherwise, it is how fast can we turn them over or put them aside and then get out of them, because it's not going to make them any money. You get a little bit of a wind of that if the general recovery is going to be 2 times the medical specials or less. If that is a very consistent thing across their matters, they may well be one of those, so be careful. Hiding insurance coverage. They may not tell you something like in California, we have something called Prop 213. If a driver does not carry the minimum auto insurance limits, they actually can only get their medical expenses paid for. They get no pain and suffering. And that's the real golden parachute for personal injury cases, to really ump the amount of damages. It's the pain and suffering. So when it's a Prop 213 case, you're guaranteed there will never be enough money to pay all the providers, because the attorney's going to take their fees, and then the rest is supposed to be for the providers. But a lot of attorneys even then try to get a third of it over to the patient, and it's wrong. Or they hide that there is no underinsured motorist coverage. One of the things you want to find and look on and get from every patient that comes to you, get a copy of their own insurance coverage. If you get that declaration page, you're going to see a couple things you want to always highlight. One is MedPay or PIP, if it's not mandated by the state. But the MedPay, you can see how much it is, and you'll see if it's reimbursable. You see that, you go after that MedPay. What you'll also see is the amount of uninsured motorist and underinsured motorist. The latter I'm going to focus a little more on. Underinsured motorist is if the adverse driver who hit him, their policy isn't enough to cover all the damages that were sustained. Maybe your patient really got severely hurt. So if your patient had a higher policy, believe it or not, the second action after resolution of the first policy, where they pay it all, maybe $15,000, the attorney is going to shift to the patient's own policy. What we find with providers is a lot of the law firms don't tell the providers they're even going after underinsured motorist or UIM. They try to hide that. You get these letters saying, oh, this is all we got was a total of $15,000, not enough to pay everybody. You hear the violins going in the background and the sobbing story. We really need you to help us out. And they want you to maybe take $500 on a $3,000 bill. But what they're not telling you is there's more money available. You have to ask. And that's one of the important things we're going to talk about later, is what you should be asking for. Then there's the MedPay mistakes we talked about. When they get that MedPay, the first problem is just holding on to it. When you hold on to MedPay till the end of the case, if it's reimbursable, of course the MedPay insurer wants to come back and get money that's still sitting on the table. But if they pay it out like they're supposed to, it's gone. It's paid out to the providers like it's supposed to. They usually almost always will waive that right of reimbursement, or it'll be pennies on the dollar. And there's a lot of restrictions on insurers even on going after, say, MedPay. But one of the biggest areas of problems, and in fact, I would put to you it's malpractice, is when a MedPay bill is issued by an insurer on your bill. Specifically, the EOB is to pay your bill. That's sent to the attorney. The attorney then takes, say, a third of that MedPay and pays out the rest. The attorney just screwed over their own client. Because when they took that third, that means 100% of the MedPay didn't go to reduce your bill. So the patient out of their own pocket has to make up that amount, even though the MedPay recovery had nothing to do with the attorney's efforts. It's one of the biggest mistakes we see in a lot of things. What medical lien recovery does is we get MedPay turnover all the time for that very reason. Another area is directing medical care. Attorneys need to stay in their lane. You have to control that, not them. I will admit, sometimes they feel they're forced, because as we get later, when providers don't do their job, they feel they have no other choice but to try to get the patient to see some other providers because they don't feel the right care is being given. Don't put them in that situation. Another foul is the not communicating. Simply, they've dropped the patient, they've subbed out, or where after a settlement's occurred, that's the first time you hear of these problems. Oh, a problem with your bill, a problem with treatment. You should have sent it to health insurance. For whatever it is, if the first time you hear it is after a settlement's occurred, probably it's not a real issue, especially if these guys are experienced attorneys. And if they know there's an issue, they would have brought it to you first so that they could have rebuttals to the insurance adjuster. One of the other big problems we have, especially in California, is attorneys settle matters and they don't let their clients know that they have higher personal financial exposure when they accept that settlement. Let me explain that a little bit more because it's really important. When a case is going to settle, usually before it settles, the attorney writes up either by letter or a sheet a disbursement listing, which is going to go to the patient to review and to sign off on. That's going to have the amount of the settlement, the amount of the attorney's fees, the attorney costs, all the lien holders' amounts, all the reductions they were supposed to have got agreed to, and then it has this big words on the bottom saying net to client. That's your patient. They're focused on that amount. If they're happy with that amount, okay, let's sign and settle the case. Here's the problem. For those attorneys who list lien reductions but never actually talk to you yet, and they haven't told the patient they're still exposed for the rest of that money, that patient very well be signing off on a settlement, concluding a case, not realizing they owe a lot more money than even what they may be getting. Now, in some states, you have common fund doctrines which does protect and make sure that a patient is entitled to a certain amount of a personal injury pot of money. But a lot of those states, and you'll need to check your own state, after the case is done, still allow the providers to sue or recover from the patient for the balance that wasn't paid by the personal injury action. In California, we do the same thing where attorneys use interpleaders where they deposit monies when there's a conflict to resolve a claim over the money, and of course going to apportion monies. Well, the apportionment is generally, when they do that, it's not a full and final satisfaction of the provider's bill. The provider can still go after the patient for the balance still owing. So that's part of the thing that a lot of the attorneys hide from providers. They hide settlement specifics. They don't show that disbursement schedule. They don't even want to tell sometimes the amount it's settled for. You have to ask them, was there any other potential sources of potential recovery? Like underinsured motorist coverage or MedPay or other third parties. You want to ask it in writing and get those responses in writing. That's what's important because they will deny something orally they said or didn't say. But when you have it in writing, it's clear. You want to have a better understanding of the applicable law and what does not apply. Some other potential game fouls. In California, especially, they like to use the 1/3 to the attorney, 1/3 to the patient, and 1/3 pro rata to all the medical providers. Well, when it's all the medical providers, and there are a number of them, 1/3 is rarely enough to compensate them well much at all. That's where the difference in profit margins matter. Because again, if the MRI company is okay with $500, their pro rata is going to be fine. But that is completely unfair to the chiropractor, the acupuncturist, the physical therapist. It does not properly or fairly compensate them. So this is not the law. Some attorneys in California will even cite a civil code provision, Civil Code 3040 or Civil Code 3045. They do not apply to private providers. They apply to healthcare networks, and the latter one was for trauma centers. So believe it or not, sometimes you can't even trust the law that is cited by attorneys. They are seeking to mislead you either intentionally or they simply don't know what they're doing. And I've come across both. Now, when they also say that your client has always agreed to take 1/3 off their bill on all of our matters. Well, whenever you hear that, what that attorney is saying is that if that was true, that means you as the provider and that attorney entered probably into an illegal kickback or fee splitting scheme. Because if that is the case, that you always reduce by 1/3, yet you submitted your full bill to that attorney to send to the insurer, that's medical billing fraud. So that doesn't exist. You really don't do that with these attorneys, but they want to assert that part of that, it's the way that it's always done. It's not. So you get into this also self-based hypocrisy. Don't you love it when you are asked to, or they say, I can only pay you 20% total of your bill? And then when you get a disbursement listing, that's why you want to get it, shows the attorney is getting 40% for their fees and costs. So they're taking no reduction and your work was maybe done years ago. So self-interest-based hypocrisy is rampant. And then we talked a little about interpleader, and at least in California, it's attorneys not understanding it, providers not understanding it, patients not understanding it. It's misuse, and then often really it's non-use. If you're a higher level provider, you've got a really big bill, you actually will like interpleader. You don't want to chase a patient. You may also have a bill that's too big for small claims. Forcing the attorney to interplead does give you the opportunity for all of that money potentially to be deposited with the court, and now you can get paid. This is one really important change in California, but it's going to apply to a lot of you in a lot of different states. California, in its rules for ethics that govern attorneys, changed in 2019. They adopted a lot of the more national rules and guidelines to California. So a lot of the things that have been incorporated here are already probably in place in your state too, and it matters. In California, not only do attorneys now have a duty of diligence, which is promptness, they are required to communicate, including with you, the medical lien holder. They have to report promptly, even to lien holders who are third parties with an interest in the funds. If you object to their attorney's fees because they did things wrong, they're not supposed to take a dime out until that is adjudicated somewhere. They are supposed to account in writing to you. That means when you ask for that disbursement schedule, they are required to give that breakdown. So in the end, these things mean they are supposed to communicate, provide. It's all about transparency. The foundation of ethics really is transparency, whether it's the attorney, whether it's the patient, whether it's the insurer, whether it's you. Here, something I was at just this past August of 2019 at the Consumer Association Attorney of Los Angeles, their convention in Las Vegas, there was an ethics panel, and a state bar court judge set out to all the attorneys in the audience that any trust account violation now in California is going to be subject to an automatic 90-day suspension. That means for 3 months, they can't practice law. So if you didn't think that the law was now changed in your favor, it is in this state. And if you've got similar laws in your states, you are the one that really can be in control. You determine what you're going to discount and how much. Let's get on to the potential game fouls by providers. First, as we talked about, it's MedPay, PIP, UIM, whatever that is. It's you not being aware of what's out there. You got to get paid on your bill, so you really should know the potential pots there are and how you can get paid for your good, hard, and competent work. Next, it's diagramming accidents. Don't do it. You are not an accident reconstructionist. In fact, if you ever diagram it, I guarantee you're wrong. And you may have just created a liability issue that didn't exist because a savvy defense attorney is going to say, hey, the patient told you here's how the cars were, when they really weren't that way. Now you created something new, so don't do it. Let's get into reports. If you're a chiropractor, for example, generally your report is not going to be the foundation of any major recovery. It's going to get more of the pain management report, the surgical report, not yours. So first thing is, should you do a report? Ask the attorney if they want a report, and do they pay for that report? And then when you do it, why are you calling it final report? Don't you have patients that come in and about 3-4 months later have flare-ups and come back? Well, that means your report wasn't final. So maybe change how you do it. Realize it's those SOAP notes that are really important. They tell the story of the patient. Type them. Make them clear. Make those SOAP notes so you're not using all medical terminology. Make it so the attorney and the adjuster can really understand the patient's path to care, including explaining gaps in treatment. It's those SOAP notes that are the gold. And by typing them, you're going to save yourself from getting into a lot of depositions just about reading your notes. So there's other things in here that I'm not going to cover because we're going to be short on time. but review these slides because it talks about a lot of them and you really should get to understand them. One group of them in the bottom is talking about the deposition effect. If you do not get paid 100% on your bills, at least a good amount, if you do not go after patients who don't pay, if you don't make attorneys pay, guess what? When you get deposed, all of that is going to be queried by the defense attorney, and they're going to make it believe that you never get paid in full on your bill, so your bill is really a false bill. So keep that in mind as you go about what you do. One thing that we did talk about a little bit before was about referring out. You do need to make sure that when the time is right, the patient's not getting helped when they should be over your treatment, something else is indicated, refer out to a specialist. Get them to that pain management doctor. I know that some chiropractors, for example, are worried that a pain management doctor is going to poach their patient, but you've got to always do what's medically necessary. And there are very few that are going to do that. Besides, if a pain management doctor is going to recommend an injection, the patient may not want the shot or want the injection. They may opt to more conservative treatment. Well, that means going back to chiropractic, acupuncture, physical therapy. That means now that bill that before was more supportable at $4,000 or $5,000 is actually could be supportable at $12,000, $13,000, $16,000 because of the injuries and the other facts that support that extended treatment. So keep that in mind that referrals are good. Get that MRI. MRIs are not just to show something doesn't exist, it's also to confirm what you're doing. So you can use it for either way. Some of the other fouls are sloppy missing paperwork. You're using a really bad medical lien. Medical and recovery, we use the best lien in the business. And why? Because I came up with this back in 2013. I've been modifying it every year because every lien I saw has been missing things. If you want a copy, get an email over to me, go to the company website, contact me there. I'll get you that in some other forms, all free of use. Just use it for only your own practice. But the problem is people are using bad liens, or attorneys change the liens and you're not aware of that and you're not addressing those changes. Another one is not keeping a communications log. Every time that you call the attorney's office or they call you, your staff should be noting it in a log, the date, who, what said. That's really important for later because when you have a lot of the fouls that occur, they try to say they told you something earlier and that communications log can be evidence. And like it says on the slide, confirm it in writing because if it's not in writing, it doesn't exist. Don't forget to help your attorney, or the patient's attorney, I should say. Type SOAP notes, bill support. Show them examples of full pay that they can send to the adjuster where you are paid 100%. Explain the gaps in treatment. If you're factoring or selling liens or taking huge discounts, you better let that attorney know that early on because they're going to have a problem if you get deposed on your bill. If you do that occasionally, that's okay. But if you factor a lot, again, that's going to be a red flag and hurt the patient's case. There's a difference again between you getting paid on your bill properly and then the effect on the PI case. They're two different things. Another one of the really big fouls I find by providers is not following up. You finish treatment, you have an accounts receivable. Like any business would do, you need to be following up on a reasonable basis, checking in on those that are involved. That means not just the attorney. Every 3 months, you should be contacting the attorney and the patient, and I would suggest even getting the information for the third-party insurer and contacting that adjuster. If you start getting different stories, something's amiss, and you better find out because maybe this case settled long ago, you weren't told, the attorney changed, you weren't told, the patient moved, you weren't told. And you should keep track of that patient, including when they move, when you call them up every 3 months and say, how are you doing? Well, that first statement is going to probably get you more referrals. Then you ask about, how's your case going? That will probably help you to get more referrals. Then the last one is, have you changed or are you planning on moving? I just want to update your information. Know where they're at because they're the star player and they're the ones ultimately responsible for that bill. And then don't do any billing tricks. It is not worth your license, not worth it for any reason. Protect the integrity of your business, you, and your industry. So don't upcode. That includes don't put some code on a PI case that you would not be putting trading treating a patient that has the exact same injuries, but it's not a PI case. If you do copay waivers, that's okay in California. You can do that, but you just can't do it on every case. This gets into that area of cash patients. You've got to be really careful when you're doing someone for cash. It's okay in California to do that, but when you go out and buy something at a store, they might give you a 10%, 15% discount, usually less. If you're reducing your bill by 50% for cash patients, that defense attorney for the other side at trial is going to make it look like your bill is not what it means, even though you've got legitimate reasons for getting paid early on that case in cash now. So realize that can affect that case. Be careful of your cash rates. Personally, the same rate should be charged whether it's insurance, lien, or cash. When you're reducing on insurance, that's because of contractual required write-downs of the agreements you've entered into or by law. For cash, if you're really going to bring it down, say more than 15, 20%, my suggestion is get the patient to fill out a financial hardship document, the reasons why they need the help, and then put that in the file, help the attorney this way so you can explain why that's being done. A big problem I've been seeing is all these companies out there that are saying, I'm going to get you patients, I'm going to handle your billing and negotiate with the attorneys, just trust us. What happens is those services generally bow to whatever it is the attorney wants because they want the volume from the law firms. And then when they're getting these really high percentages of your bill, of your portion, that means in the end you get very little. So if it sounds too good to be true, it probably is. Now, there are some really good, those online listings where doctors that take them on lien that are accessed by attorneys, where you pay maybe a monthly fee. That's okay. Those are good services. Just be careful that a lot of attorneys have wrong expectations that you are going along the contingency train. That gets back to setting up realistic expectations. One of the other real big foul areas is when you do agree to reduce your bill, you need to put more on that document. You should be having how much that the amount is settling for that your agreement is based upon, because if that changes later, you should get paid more if it's higher. It should have a time limit for acceptance and a time limit for you to receive the funds, which are reasonable. You can always come back and if the time limits pass, renew the agreement. But when you don't have those, you're going to have attorneys that say, God, you agreed to this a year ago. So you didn't tell me you changed, so we did it based on that, even though you spent another year of overhead chasing them on it, or other things occurred. So list those assumptions on that written document and make sure, again, it's always in writing. The support for reasonable fees, I'm going to suggest a lot of you go to a third-party company called Fair Health. There's a website, fairhealthconsumer.org. I challenge you to put in your regular codes for your normal PI fees, put them in Fair Health, or put the codes in. See what Fair Health says is the rate for your zip code in your area for your specialty, and compare it to your rates. You may find you're undercharging. You may find you're overcharging on some, at least based on there, but you're also going to know if you're within the ballpark. It's a great help for that bucket of cap providers to use. And just realize, you can go back a long time on a lot of these liens that are owed. The statute of limitations for you when you have that lien signed by both the patient and the attorney is 4 years. 4 years not from the date that you did the services. It's generally 4 years from the date of the breach of the contract. Well, when can a contract be breached first in PI? That's going to be generally when the attorney receives the funds from the settlement when it's all done in their trust account. That starts the clock ticking. So don't be surprised if you can go back 6, maybe 8 years, who knows, maybe more depending upon the case, to get paid if you were diligent in that follow-up and they kept saying pending, pending, pending. So keep that in mind. This slide is about when you're going to get deposed. This is going to vary depending upon the state that you're in, and this is geared to California. Realize that a lot of attorneys have tried to have providers testify as experts, but not pay them as experts. In California, if you're simply reading your notes, yeah, they can pay you just a little witness fee of $35 a day, and you're paying like 20 cents a mile to get there. But if they're asking you for factual opinions or opinions on treatment, they got to pay you as an expert. And it's called out here a non-retained expert. So don't let them abuse you in what you're doing or how you're being paid. This slide will be really great for you to review if you are going to get deposed and how to approach things, and you can always contact me later. So let's talk about the guidelines for a win-win. We've covered things. We're going to summarize it right now. Know the players in the game stage. Help the attorney and the patient with the PI case. You're not being an advocate for the patient because you're a neutral provider, but do the things that's going to be supportive of a case and not cause a problem on the case. Do your due diligence. Build a strong foundation for your practice. Operate with full transparency and require that of everybody, not just you, but the attorney. Your fees are a great example in your bill. Your bill, personally, when you're sending out that bill, you should be sending it out monthly to both the attorney and the patient. Make sure they both know. That gives them an opportunity to say, hey, if there's something wrong. When you don't have full transparency on your bill and early, that can create problems. And of course, when the attorney's not having full transparency on the settlement and doing it early before the patient finalizes it, that causes problems. Communicate early and often the results and the issues. Make sure you document everything because that's the record, and over years you need that. When it's oral, people will deny they ever said it. And make sure you've got that clear, detailed paperwork. Have the best lien. Get our lien. You will really, really want that. If something has to go to some kind of litigation on it, you'll want that good contract. Timeliness matters, being prompt and proactive. That includes being you. Don't just sit back and wonder if the patient is moved. Call and find out and keep track of them. Assemble that comprehensive go-to medical team. Know who, if you've got to refer, who are going to treat your patients properly, competently, and take it on lean. The higher bucket of providers, the surgeons, the surgical centers, the pain management, even the MRI, they realize the profit margin specialty and should help to protect the other buckets' bills more so than the attorney will. Lay out those expectations clearly, and sometimes things change. Reset them yourself, the attorney, the patient. Like I said, follow up quarterly, both with the attorney and the patient. In fact, quarterly, go to the state bar websites I've been talking about, check up on the attorney. In the meantime, I'll tell you, some have died, have been suspended, disbarred. You can find out from public documentation on them, so make use of that. Spot the game fouls. Don't just accept them, act. Realize that a lot of the rules that attorneys have, especially now in California starting in 2019, but in a lot of the states, really are in your favor to communicate with you, to account to you, to be fair with you. Make sure when you do agree on a reduction, which you're not required to do, the patient owes the bill regardless of the outcome of the case. That means if the attorney dropped the patient, they owe the full bill. If they lost a trial, the patient owes the full bill. So if also that it didn't get enough in settlement, the patient still owes the full bill. But it's okay to still look at reductions. When you do, list those contingencies and the assumptions upon which they're based. You follow this up until the final whistle blows of the game, and that means when you are paid. Work together, not against each other, and educate yourself and your staff. Continue that education, including at mlrportal.com and the resources we have for you, and they're going to grow and even include down the road other states. In conclusion, remember, all players have a legitimate interest. The insurance company, the attorney, the patient, and you. Never assume. Remember, when you assume things, it makes a you-know-what out of you and me. Called the ABLPP. Always be learning, always be prepared, always be proactive. And as you go about all this, act with integrity. Know your rights. Stand up for yourself and even for your staff. You've got a law firm that's abusing your staff verbally or in writing. You get that out of your staff's hand. And if it can't be done by you directly, then you get it, whether it's medical in recovery or somebody else, you protect them. Don't accept the game fouls. You now have got more knowledge to go out and act and correct that and not get abused, and protect even your patient more because they aren't being aware of things their attorney oftentimes has done that it has now affected them financially. In the end, be not just a great medical provider. You're also a for-profit business, so be a great business owner. And if you need help, get it. Your peers, the associations, Great organizations that are national, vendors, and the pros do it. I want to thank you for your time. I am here to help you. Medical Lien Recovery is here to help you. And I hope you've gotten a lot out of the ethics of personal injury. Go back and review these slides. Contact me for any question you have. Have a great year.